And we're back. So, let's go back to the Alien Sedition Acts and other acts like it. So, the Alien Sedition Acts and the Espionage Acts and something like the Patriot Act would probably be a good example, a modern example of this. We have at times when government is going through great turmoil or great fear, we have times where we act outside of the Constitution at times. The Alien Sedition Acts and the Espionage Acts are acts that said you couldn't speak out against government or actions of government, which are clearly unconstitutional. The Patriot Act was the ability for government to look into citizens without having to get warrants in certain instances because we were fearful of terrorism. Again, now that we're almost 20 years removed from the attack of 9/11, the Patriot Act has been deemed has been stripped down and has been deemed parts of it have been deemed unconstitutional. So what happens is over time, actions of government especially when we're not in war or not going through a great turmoil, are going to be deemed unconstitutional because really they are. Espionage Acts and Alien and Sedition Acts, where you can't speak out against government, are a violation of your First Amendment, freedom of speech, and are deemed unconstitutional. So there are times, however, where speech can be regulated. And there are some types of speech that are deemed dangerous, and we've said you cannot speak in this way in this certain context. So your freedom of speech is not absolute. You just can't say whatever. We're going to see in these two instances where there are rules that say, or in a couple instances where there are rules that say you cannot speak in a particular way because it's going to cause a danger. And that's where the Clear and Present Danger Act comes in. Clear and Present Danger Doctrine. Congress has had a right to restrict speech of such a nature as to create a danger in certain contexts. Again, Congress has restricted such speech which can cause a nature to create a clear and present danger that will bring about the substantive evils that Congress has the right to prevent. So words that you can't say like in a crowded movie theater. You can't just jump up and say gun or bomb or fire. Well, why? Well, human nature is what human nature is. Your body will click in and have a response, fight or flight. And if there's nothing to fight, so say you yell gun, some people are going to look for the assailant and try to stop them. But again, if that does not exist, so if there's no gun present or there's no bomb present, we're all going to switch to what is called the flight syndrome, where we're going to try to get away. And some people flee by hiding, or some people flee by running. And in a theater where everybody's in rows, people are gonna, if you yell out gun, people are gonna duck down, some people are gonna run out, and usually the hiders get trampled by the runners, and somebody is probably gonna end up injured or even dead in that context. And if there was no gun, you're gonna be punished for the speech of creating that danger, as if there was that danger. So you're gonna be punished for your acts. If you yell out when there's no danger, that there are danger that exists, kind of that boy that cried wolf syndrome, you're gonna be punished for that behavior because you're creating a danger when there is not any. And that's one of those instances where you can be, and again, you're punished after you do the speech, but you're punished for your speech. When your speech causes a behavior, the direct incitement of an action. So there are a lot of people who will get up and speak in front of groups and advocate certain behavior. And sometimes when they get up and speak in front of groups, that behavior that they're advocating is going to be considered extreme. And I'm going to let you know that speech is allowable until somebody acts on your word. So say I'm standing in front of the Capitol building of Georgia and I'm ranting about how we don't like the representatives and we should vote them all out no matter what their party. We should vote them all out because they're terrible. And I all of a sudden switch from that speech to, you know what? This Capitol building is a symbol of, oppression and all these other things. And I start advocating, let's burn the building to the ground. I am free to say those words in my speech until you start realizing, don't realize that I'm nuts and start believing what I'm saying and start putting my words into action. And so I incited you. I provoked you to act in a particular way, and you listened to me. And so when you go to burn the building down, I'm going to be responsible for telling you to do such. Now, there is something that we have to take into consideration here, because say, you leave my demonstration and you go fill up a gas can with gas and drive directly back to the Capitol building and start pouring the gas on the building and start lighting it on fire. Again, my words led to your direct action because you were in commission of my action that whole time. And so I'm going to be responsible for what happens as if I also poured the gas on the building and lit it on fire, because again, you listened to me. Now, if you go home, have dinner with your family, watch TV, go to bed, and then wake up and then go get the gas and then go back to the Capitol building and light it on fire, there's enough time for you to have a cooling off point and realize that I'm crazy. And so my words are not necessarily going to have the same effect in that time because you had a cooling off period. And so since you did do those actions and you had that cooling off period, we could reason that, there's something wrong with you in that case, and that you should have realized that I'm crazy. And so that's something that comes into play. So there is a cooling off doctrine that goes along with the direct incitement test. Again, direct incitement has to kind of correlate. There usually there needs to not be a break between my speech and your going and doing that action. But again, there could be some cooling off period time. But again, that's another example of where a speech could be held accountable. So speech of the press. So one of the ways in which speech is probably the most prevalent in our society is through the press. Our press has evolved and expanded. I remember when I was a kid, there were very few press junkets. We had the major news, and that was pretty much, outside of newspapers and radio, it was just the major news. Now we have all of these different news organizations, and they have different, different beliefs, political beliefs backing some and things of that nature. So it has changed a little bit between my youth and the youth of today, and how we look at it today. But the press, for the most part, in the history of America, was kind of the eyes and ears of our society. It would keep us aware of what was going on with government more than any other object, and then report on those behaviors. And so we've given a lot of protection to the press for that reason, because again, it usually kept us abreast of what was going on. And it's important in that regard, because if we don't know what's going on with our government, it's hard to stop government from doing the things that are wrong. And so we see in 1970s and even during this time that there is a heavy presumption against government infringing on the press. New York Times versus United States could not prevent the New York Times from publishing secret Department of Defense documents, even though they were illegally furnished to the New York Times. So what happens is this. During the time of our Vietnam War, there was some debate over whether certain actions were prompted by outside forces or certain actions were just our government doing those behaviors. And so documents were stolen from the Department of Defense. And again, that wasn't a legal action. And a document ended up at the Washington Post regarding the action of our government in the war. And so the Washington Post publishes part of that document. And the government comes in and says, whoa, national security. You're violating national security, and we have an injunction, which is a document that says you cannot continue to do a behavior. And we have this injunction that prevents you from publishing anymore. And the Washington Post said, okay, we won't publish anymore. But they've put the document in the mail to the Chicago Sun-Times. And it gets to Chicago, and the Chicago Sun-Times publishes the next section of the document. And the national government comes in and says, whoa, national security. Didn't you see what happened with the Washington Post? Didn't you see that publishing this document is a violation of national security, and we have an injunction, and you cannot continue to publish this document? And the Chicago Sun-Times says, we understand, but they put it in the mail to the New York Times. And the New York Times, the government is not dumb. They actually beat the document to the New York Times. The New York Times gets the document. They're about to publish it, but the national government walks into the New York Times and says, we have an injunction on a document that you guys are about to receive, and you cannot publish it in the New York Times. The New York Times says, whoa, we haven't done anything. You're punishing us, and we haven't done anything yet. And the issue goes to the Supreme Court, and the Supreme Court rules, yes, you cannot punish the press for an action that they have not done yet. These these newspaper companies are separate entities, and the New York Times has not done anything yet, so you cannot punish them before the fact. It's prior restraint. It's unconstitutional. And so the New York Times then realizes what they have in their hands, and they pull all their other ads, and they publish the document in its entirety. And so now the whole document is out there. The Pentagon Papers. This is the Pentagon Papers case, and there's nothing to be done about it. The document is out there in the world. Nebraska Press Association versus Stewart. In regards to preventing speech, such actions by government carry a heavy presumption against constitutionality. If government is trying to quash or diminish the speech that press is doing, with the history of how it's been done in the past, we usually view those the government's ability to diminish what the press is saying as there's something going on in government. With the history of where government has done something wrong to the people, we usually default in the press's favor. So we have actual stated speech. So we had speech that was spoken, and we had speech that was written. But now there is other types of speech that might be written down or expressed, but we don't always know what it means. And symbolic speech is that speech. Symbols, signs, and other methods of expression generally considered to be protected by the First Amendment. A lot of what we interact with isn't always clearly stated. So there's a couple questions that I'm going to ask. Can I walk around with a jacket that has a picture of a person giving the middle finger on the back of it? And so when we see the middle finger jacket, if I were to walk into a government building with a person or just somebody giving the middle finger on it, can I do such? Is it constitutionally protected? Well, it's symbolic. It's symbolic speech. It's saying something. The question is, who is it saying it to? Because with a middle finger jacket of a picture with somebody giving the middle finger, we don't know who that middle finger is expressed towards. So it could be, if I'm in a government building, being expressed towards government, or it could be expressed to a particular group, or it could be expressed to everybody. Because the jacket is just somebody giving the middle finger, it doesn't really express that clearly to everyone. So is it protected by the Constitution? Well, it's speech, so it's protected within a reason. We might, depending on where you live, it might be deemed as obscene, and you might run into some issues, and you might have to argue your protection in court. But it's protected. What if in the 1970s I were to walk into a government building with a jacket that says the F word and then the draft? So F the draft on the back of it in a government building during the Vietnam War. Is that constitutionally protected? Well, yes, that's also constitutionally protected. Actually, there was a case about it called Cohen. And Cohen is the F the draft case. If you ever Google the F word, the draft, I don't know, don't do it on a school computer, but F the draft case. And he walks into a government building during the Vietnam War with his jacket. And it raised some issue. He was arrested, and it went all the way to the Supreme Court, and the Supreme Court said that was also protected. So let's kind of balance those out. So which of these jackets is more protected? My middle finger jacket or my F the draft jacket? Some people probably would argue that they're the same. The middle finger jacket is kind of saying the same thing as the F the draft jacket, but well, probably not. With my middle finger jacket, we really don't know who we're directing the speech towards. With my F the draft jacket, we know exactly who the speech is being directed towards. The jacket is referencing the draft, which is a government action. And so my jacket is clearly, if I have the F the draft jacket, is clearly a direction toward the government. And so what I'm trying to say is, the more directed your speech is, the clearer your speech is, the more protected it is. If we're clear with the symbols saying, the more protection it's going to have, because it has more social value. We're able to understand it. It is clear. It has more social value, and the more social value something has, the more protected it usually is. So, our symbolic speech is based on a trade of ideas, and this is what we're doing. My F the draft jacket is trading an idea. It's telling everybody that the draft is bad in some way, and I'm upset with it. It's not as clear as it could be, but it's protected by the Constitution. The middle finger jacket, again, it's expressing something, but it's not as clear as it could be. So Stromberg versus California, flying on opposing country's flag in opposition to governmental action is constitutionally protected. So you can fly a flag of another government, and that's protected by the Constitution. Tinker versus Des Moines, wearing black armbands in opposition to the Vietnam War was considered protected speech. Again, as long as it's clear and it's not like a gang sign, I guess. So you could probably do it in school. Again, this was a done in a school district, and you know, there's certain symbols that we have that I grew up around. I grew up in, I lived in Chicago and then came back to the suburban Atlanta. But when I lived in Chicago, we had young ladies that used to wear yellow bandanas on the top of their hair, and they were part of the Latin Queens, and it was a female gang, and that was signifying, that they were associated with that, and that was not deemed to be appropriate, the wearing of certain color bandanas in your hair, because there was a clear notice that was a gang symbol. And so again, it's a symbol, it's symbolic speech, but not protected in schools. Now, if I wore a black armband that said, during that same time, because we were in the Gulf War, if somebody wore an armband that said, in the war, that would probably be deemed as a acceptable expression of speech. Depending on how you view it, might be different between, how you view it, but it's still constitutionally protected, where, the symbolism of gangs is a dangerous symbol, and it's not as protected. It is not protected. So, now, some types of speech we may not like, but some types of speech is protected. And unfortunately, hate speech is protected within reason. This is a very interesting slide, and if you don't watch this video, you're probably going to get this answer wrong when we do the test. But hate speech, RAV versus St. Paul. In St. Paul, Minnesota, there was an ordinance that made it a crime to engage in speech or action likely to arouse alarm or create resentment on the basis of race, color, creed, religion, or gender. A teenager burns a cross in a black family's yard. The teenager could not be charged because the ordinance was deemed to be prior restraint and was deemed to be unconstitutional because it violated his free speech. And the Constitution said that we were silencing speech on the basis of its content, which means, just because it's hate speech doesn't mean that it's not allowable. Now, let's make this a little clearer, because if you did this today, and you came to my yard being an African American and you burned a cross in my yard, that would be illegal. It's an assault. It's in the history of the United States, burning crosses were a sign of intimidation, and that would be an assault on my person, and you would go to jail for assault. Now, if you had a belief and you burned a cross in your own yard, that's hate speech and it's allowable speech. And maybe, depending on how you view it, you might not view a burning cross as hate speech, but again, it's interpreted in most circles as that. And so if you burned a cross in your own yard, that's your freedom of speech. You burn it in my yard, you are breaking a boundary that belongs to another person, and that person is a person of African American heritage. And most times, burning crosses on the property or in in the presence of African Americans for the purpose of conveying a particular message is hate speech, and is intimidation, is designed to do intimidation, and that intimidation is against the law. So when you look at this today, hate speech, depending on the context, is allowable. You do it in your own yard. Hate speech, constitutionally protected. You do it in my yard, that's assault, not protected. It's against the law. You're going to go to jail. There are other types of speech that are not protected under the Constitution. Libel and slander, fighting words, obscenity, and lewdness. So libel and slander are two forms of defamation. Defamation is defamation. Again, defamation, type of speech that harms the character of another person, that is defamation. Libel, you think about a library has a bunch of written things that are written down. Again, the more technologically advanced we get, the less written text we have. But libel is written statements that defames the character of another person. Slander are spoken statements that defame the character of a person. Libel and slander are not protected by the Constitution. However, this is one of those times where rights get pitted against each other, and So somebody's First Amendment right of freedom of speech is going to get balanced against your right to privacy a little bit. And so if I make a vague statement about a person, the unfortunate fact about this is they have to prove that that statement is untrue. If I were to say about a person and say that they, touch little girls or something, and I said, Joe down the street touches little girls, unfortunately, Joe's going to have to prove that he doesn't touch little girls in order to bring he can always bring a lawsuit against me, but I don't really have to prove that he touches little girls. He's got to prove that he doesn't. Unfortunately, my freedom of speech outweighs his right to privacy. Now, if Joe is a student in my class and we have class Monday at 5 p.m., and he's there every Monday, and at 5:15 I said, last Monday at 5:15, Joe was touching a little girl down the street. Well, no, Joe was in my class, and other students were witnesses that Joe was there the whole time, and Joe could bring a lawsuit against me, or even have me arrested for a violation of his rights. That's a different story. So it depends on how this is crafted. But again, libel and slander are both forms of defamation, and they are both neither of them are constitutionally protected. Depending on who you are, you may not have the same protection as the average person. If you are a public servant or you are a public figure, you don't have the same protection as the average person. I'm not an average person. I'm a teacher. I'm not out there in society. And because of that, my privacy right is a little bit stronger than a person who subjects themselves to the public. So your public figures, like politicians, my wife is running for office right now, and so because she's running for office, she's open to a little bit more criticism than the average person, and people can say things about her that and we haven't run into this yet, but people can say things about her that might not necessarily be true, and they're protected because she's a public figure, or she's trying to be a public servant. Public figures, your famous individuals, again, put themselves in the public sphere, and because they put themselves in the public sphere, again, people can say things about them which may not necessarily be true, but they don't have a stronger protection because they purposely put themselves in the public for a benefit, and it reduces their privacy right. So depending on who you are, your right may be changed because you've subjected yourself into the public, and the more in the public you are, the more reduced your privacy is. Again, if you take the president in particular, there's a lot of things pro and con said about the president of the United States, but they have a lot less protection because they've put themselves in that public sphere. Fighting words. Words by their very utterance intend to inflict, or tend to inflict an immediate breach of the peace. Certain words in our society would be deemed fighting words. But the problem with fighting words is this. Now, like you could say, like, what's an example of the fighting words? The N word or the B word for ladies, or, other words have been used as examples of fighting words. But the rule is this: you have to use the rational person test. The rational person test. Would a rational person be led to fight if this word was uttered in their presence? Now, the thing about it is, the rational person doesn't exist. The court, or whatever court is hearing the case, is going to determine, would a rational person, in the mind of the court, would a rational person act in a violent way if this word was said? And if the rational person in the court's mind would have acted that way, your words aren't protected. But again, you're asking the court to create an imaginary person to rule on that standard. So again, you might think what they say is fighting words. That does not give you the ability to punch them in the face, because again, you are battering them, which is against the law, which you can go to jail. Your action might not be protected, or probably won't be protected, just because you think it's fighting words. Again, it's the court's decision to determine if it's fighting words or not. Obscenity. The lower courts have said whether a work depicts or describes in patently offensive way sexual conduct specifically defined by state law, and whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So obscenity is interesting because some things that are obscene are not necessarily or can be protected by the Constitution. And so there's two definitions here: whether the work depicts or describes in patently offensive way sexual conduct specifically defined by state law. So this is a state by state criteria. Whether I live in Georgia, and what happens in New York City might be okay, might not be eligible to happen in Georgia. In New York City, they have a law where women can walk around topless, and that law comes out of the ability of women to breastfeed their children without being harassed by because they're exposing themselves, and kind of expanded into all women having the same right to be free to show their chests that men have. And so women in the city of New York have the ability to do so. That is not okay anywhere that I know of here in the state of Georgia. Maybe there might be parts of Atlanta that's okay in, but that would be deemed as obscene here in the state of Georgia. And so the context and the place that some of this obscenity is done is going to be taken into consideration. So what's okay in New York might not be be necessarily what's okay here in Georgia. So that's an example of that. So where you live determines, helps to define that definition. And then we have to take into consideration something else: whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. The statue of David, naked man, is considered artistic. It is a naked man. And so, depending on if you take the first definition alone by itself, it would be probably perceived as pornographic because he's nude and standing there as a statue. But again, it's art, so it's allowable as protected speech. Pornography probably is the most example of pornography of consenting adults is probably the most relevant example of this, where it exists in our society. But again, it's obscene, but it's still constitutionally protected. As long as it's consenting adults, it's allowable because there's some literary, artistic, or scientific, or for some rookies, I guess, some educational value in the dynamic of pornography. And so you have to take that into consideration. There's something gained from it. There's some social value in it. And because there's social value, it's protected in certain ways. Now, I don't have a lewdness slide because, again, it's probably, if I made one, it would probably get me in trouble. But I would say lewdness is where you have something that is so obscene that there is no social value. That would be something that is lewd. There is anybody looking at it could determine that nothing of value can be gained from it. That would be lewd, and nothing that is lewd is protected under the Constitution. And again, the last part of the First Amendment, freedom of assembly and petition. Peaceful assembly for lawful discussion cannot be made a crime. Again, we all can meet and we all can discuss what is allowable under the Constitution. It's very interesting because this slide only has one slide. Petition only and assembly only have one slide. But it might be the most important of our First Amendment rights, because if you can't be where you need to be to pray, if you can't be where you need to be to gather information, if you can't be where you need to be to say that information that you gathered and to tell it to others, how really valuable are the other rights found in the First Amendment? Even though we don't give petition a lot of credit, it might be one of the more important of the other four, the other three that we discussed under the First Amendment. All right. So, the Second Amendment. The right to keep and bear arms. Most colonies required all men to keep and bear arms, and all white men of the colonies were deputized to defend their settlements against Indians and European powers. Again, that was the militia. We don't have a culture that has a militia today. Now, you might have states that have state militias, but more than likely, you have state National Guards, which are connected to the national government. So you don't have an official militia anymore. The right to keep and bear arms is closely held to the idea of the ability to revolt against government tyranny. That's what the Second Amendment is designed for. In case government is unwilling to give the consent of the governed back to the people, it is the right of the people to again take that back and then to issue a government that is based on the consent of the governed. So if your government has arms and to protect itself from outside entities and protect itself from internal strife, it is the right of the people to also carry those arms to overthrow that government if it becomes outside of what is deemed to be appropriate by the citizenry. That means all the vast majority of the citizenry must decide that government is no longer arguing or preserving the rights of the people, and is no longer preserving the consent of the governed. And the only way to ratify or to make sure that things are put back to where the consent of the governed is followed is for us to overthrow it. That's the purpose of the Second Amendment. Now, again, we haven't seen the Second Amendment apply to everybody the same. We talked about Barron versus Baltimore and Dred Scott. These are two cases where slaves were given or had firearms, and that action was deemed illegal. And because of their status as human beings, they didn't have the Second Amendment right to bear arms. Again, maybe people will argue whether they're not citizens or certain instances. But again, the right to bear arms wording has never changed, but it has applied to people differently in the history of the United States. And so, again, we've seen that's kind of one of those areas where substantive due process comes into play, where the wording of an amendment or a law hasn't changed, but our understanding of it has, and how it applies has. There are some amendments we're going to skip. The Third Amendment, the right to quarter soldiers, is important. So you're protected from housing soldiers in your home if you do not choose to do so. Again, if you wanted quarter soldiers and house them in your home, that's your right to do so as well. But again, that protection has not been given to the states. But again, depending on your state, vast majority of states have that protection within their state constitutions. The Second Amendment, again, the right to bear arms. We've seen over time that there's been a huge expansion of the right to bear arms. Again, citizens of the United States can have automatic weapons, depending on if they apply with the federal government to have them. Again, in certain districts like Chicago and D.C., you used to not be able to have firearms, period. But the expansion of those rights has expanded to those, especially since 2010. So the Fourth Amendment and searches and seizures. The Fourth Amendment, writs of habeas corpus, which means bring the body forth. So writ of habeas corpus means a petition to bring the body forth. Court order in which a judge requires authorities to prove that a prisoner is being held lawfully and allows for the prisoner to be freed if a judge is not persuaded by the government's case. Again, you can be detained for a certain amount of time lawfully, but after a while, after a rational amount of time, it must be proven that you've done something to give the ability for government to hold you further. And that's connected to our Fourth Amendment. The right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So again, this kind of alludes to a right to privacy, but again, it doesn't say anything particularly about a right to privacy. It alludes to one. So again, it protects from unreasonable searches and seizures. There are certain things that happen within your home that are private and can be protected, and and government must have some sort of reason to search that area that is sacred and protected. Now, there are areas in which government can search. Again, persons who are being arrested can be searched. Again, you're about to enter a jail, or for the safety of an officer, you can be searched for safety purposes. Things in plain view of an arrested person. So again, you're pulled over and you're so high you forget that there's a gallon bag of marijuana in the passenger seat. Again, something that's in the plain view that anybody can see is not something that is private, and so you don't have a protection to something that anybody can see. Place where an arrested person can touch or reach. Again, if they find that gallon bag of marijuana in your car, and the reason that you didn't hide the gallon bag of marijuana is because you hid the gun that was stolen under your seat, and you're being arrested for your marijuana, and they search the areas around where you're sitting and they find that gun, well, you're going to be charged with that gun as well. So those are certain things that come into play. So there are levels of suspicion that exists. There are two levels mainly: reasonable suspicion, which is a lower level, and probable cause. So reasonable suspicion is the lower level, which means the actions that you are doing usually mean that a person is up to no good, which allows for somebody to be searched. That's a lower standard. So if I'm the director of Georgia Military College Eastman, and I have a building and nobody's in that building after 9 p.m. at night, and for some reason there's somebody walking around my building at 1 a.m. in the morning when nobody can get in, and they are searching they're flashing their light on the building and trying to try to get their way in. If the police pass that and see that, reasonably that person is up to no good, and they're going to detain that person to discover what they're up to. Again, that simple detainment is a violation of your Fourth Amendment right, but at that point in time, because more than likely what you're doing is up to no good, there's a reasonable suspicion to stop and search you, and that's allowable. Probable cause means that there's a reason to search somebody. Smells such as marijuana smells emanating from somebody's car, or a action that's being visually commenced, which is illegal, is probable cause for you to be searched. You get in a fight, and the police are going to arrest you. They have probable cause to search you. Again, you're going to be put in a jail, so there's reasonable reason for them to search you. And they search your person. They find that the drugs in your pocket as well. Again, they could search you because you did an act that gave them probable cause to search you further. So those are the things that come into play. So there are other things that lead to searches as well. So warrants are a government-sanctioned search. So you can be searched if government has enough probable cause and is signed off on. Warrants must be obtained by a neutral and detached magistrate. That means a judge that is not connected to the issue, prior to conducting more extensive searches of people's homes, cars, offices, and other places of privacy. So I used to watch a show about drug houses. And one of the things about marijuana houses, especially in cold temperature areas, is they are able, if you fly a plane way up in the sky over a community, in drug houses, the lights that are used to grow marijuana are very hot, and that heat that's created gets captured in the attics, and the heat signature of a home that has a grow in it is significantly higher and looks almost like a Christmas tree light on the sensor, and that they're flying over with, that heat sensor that they're using. So all the other houses are bluish white, and then all of a sudden they see a house that's completely white. It's looks like a big flash of light in that camera. They're more than likely, with the experience that's been gathered, there's reasonable suspicion that somebody's up to no good and doing something, because nobody's going to keep their house at that temperature, because the house is in 100 degrees plus all the time. And so nobody's going to live in a situation like that, and so that gives them probable cause to search. So they're going to go to a judge to give the judge their evidence. The judge is going to sign off and say, yeah, that's enough evidence to search that home, and they're going to have a warrant to search that home. And more likely than not, they're going to probably find a grow in that, because that's usually the only reason why a house lights up like that, unless you have some sort of other, maybe you have a computer farm in the house, and you have a cooling system that dumps all the heat from the computers up in your attic. I don't know. That's the only logical thing I can come up with at this moment to give something an analog similar. But that's more than likely not the case. Now, there are some instances where warrants aren't really needed. Vehicles, because of their mobile status, aren't given the same protection as your home. My home, and the vast majority of homes, aren't that mobile. Even mobile homes take time to be moved from place to place. And so they're given, homes are given a far higher standard when it comes to searches, because I can't move from this place that I live in a short amount of time, and I want to leave my things, and so usually if a warrant is needed, they'll just make sure they secure the home, and nobody's allowed to go in until the warrant's gathered, and then they can come back and then search the premises with a warrant in some instances. A car is different. If I'm driving down the road and somebody pulls me over, if they need a warrant and they have to let me go, in 2 hours I might be in Alabama. Or Florida, well, not Florida, not from where I am, but I might be in Alabama. So those are some of the things that need to be taken into consideration. So vehicles are given a lot less standard, and so that might be a reason why somebody can search a vehicle. A dog sniff, which is constitutionally considered not a search, can constitute enough a probable cause to search a car. So you're detained. The officer pulls the dog out of the car. You are not, well, a dog sniff is a search, but you are not privy to the smells that emanate from your vehicle. So what's going on in your vehicle is private to you, but the smells that emanate, like, so if you do have weed in your car and it is strong enough to, the smell is strong enough to exit your vehicle and the dog can smell it out in the atmosphere that's outside of your car, that's not deemed a search. And so, but that's enough probable cause for them to search your vehicle, and they can search your vehicle, and then they do find the weed because the dog hit on your car. Again, they did not need a warrant for that. So that's going to, The Fifth Amendment imposes a number of restrictions on the federal government with respect to the rights of a person suspected of a crime. So there are your rights of the accused, which is your Fifth Amendment, the rights given to people who are accused of a crime. And then there's your procedural trial rights that fall under the Sixth Amendment. So let's look at your rights to the accused. So if you're accused of a crime, there are certain privileges that you have. One, you are not required to testify against yourself, because that's self-incrimination. No person shall be compelled in any criminal case to be a witness against themselves. So you do not have to witness on your own behalf. We call it taking or pleading the fifth. A lot of people will use that as the moniker. This is born out of Miranda versus Arizona. Miranda, Supreme Court case that was used where police used coercive tactics to coerce a confession. So Miranda was arrested for kidnapping and rape. I think on your notes, well, actually, I use the same notes as yours, but I missed out the E. So rap is not illegal, but rape is definitely illegal. He was arrested for kidnapping and rape. He was identified by the victim. Police bring him in and sit him down and are trying to get a confession out of him. And for hours and hours and hours, they are asking him if he raped this lady. And Miranda, as a citizen, does not know his rights. And prior to 1960, we kind of legally assumed that people knew what their rights were, which is not true. A lot of people really don't know what their rights are. And so Miranda is held for hours and hours and hours. And eventually, after a significant amount of time of being questioned, outside of what would be the norm or what would be a reasonable time to question somebody, and he doesn't really know that he needs to ask for an attorney either, he finally admits to doing the crime. And so the case goes back, and Miranda is, it's found out that Miranda was questioned in the way he was, and the case goes to the Supreme Court, and the Supreme Court rules that when you arrest somebody, they need to be told what their rights are, because they may not know what their rights are in these circumstances, and you cannot take this extreme form of asking them to coerce a confession. And so now we have the Miranda warning. You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand these rights? And then that last question is, do you understand these rights? And you're going to say, well, yes, I understand these rights. And then they're going to ask you, start asking you questions. And that's when you say, well, I don't want to be asked any questions, or I need to talk to my attorney. And then that's when they stop asking you questions. Now, the biggest questions that I always get about this is, if somebody doesn't read your Miranda rights, are you going to go free? Well, it depends. But so say, you're about to burn a house down, and I'm driving past you as a police officer, and I see you throw the kerosene on the house and then light the match and throw the match on the house. And I arrest you for lighting the house on fire because I visually witnessed you light the house on fire, and I put you in the car, and I take you to the jail, and we book you for arson, which is the crime that you were committing. And you go to the judge and say, he never wrote me my Miranda rights. The officer's going to come to the officer and say, and you're going to be put on the stand, he's going to say, officer, did you read him his Miranda rights? I'm going to say, no. And they're going to say, well, why didn't you read him his Miranda rights? I'm going to say, I didn't ask him any questions. The Miranda warning is basically for gaining information that you would not have gotten other than asking somebody that information. And so if I don't ask you anything, I'm not violating your self-incrimination right, the right of against self-incrimination. And so you're still going to go to prison for arson. So keep that in mind. So just because they don't read you your Miranda rights doesn't mean that you're going to go free. Now, depending on the information that they're gathering and how they're gathering it and what they're doing, that's a different story. But again, in that scenario, you wouldn't go free just because you weren't read your Miranda rights. Under the Fifth Amendment as well, we said we have double jeopardy. Nor shall any person be subject for the same offense to be twice put in jeopardy of life and limb. So, double jeopardy is very specific. We are talking about the same specific criminal offense. Again, I'm going to say it again. The same specific criminal offense. The reason I'm saying it the way I'm saying it is, if we just say double jeopardy is the same offense, that means if I rob like a bank, the Bank of Eastman in Eastman, Georgia, and I go to prison for robbing the bank, and the day I get out of prison, I decide to rob the Bank of Eastman again. If double jeopardy was just the same offense, I could just rob the Bank of Eastman every day for the rest of my life if I wanted to, because I've already gone to prison for robbing the Bank of Eastman. No, we're talking about on the same day at the same time you rob that bank. So today is April the 9th or April the 9th of 2020. I robbed the Bank of Eastman, and I go to prison for 20 years for robbing the Bank of Eastman. The day I get out, I decide to rob the Bank of Eastman again. Well, this is a different day at a different time. It could still be, say I did it both times. I robbed the bank at 1 o'clock on both days. Just because I robbed the bank at 1 o'clock on both days is a different time, a different date. That's a different offense. I'm going to go back to prison for robbing the Bank of Eastman, even though I went to prison for robbing the Bank of Eastman previously. We're talking about the same thing that was done, the same action done at the same time in the same jurisdiction. So, if it's a different day, if it's a different time, if I rob the Bank of Eastman at 1 and then I come back and rob it again at 4, those are two separate incidents. So I could go to prison for robbing the Bank of Eastman twice in the same day. So again, it's the same specific criminal offense. Now, that being said, we have two separate enforcement jurisdictions, which we talked about in Chapter 3. And so the federal government and the state government, since robbery is illegal in both, could find me guilty for robbery of the Bank of Eastman twice in that dynamic, and I could go to prison separately for those. But in our modern understanding of crime, once you've done your time for an action, you usually do not get retried by a different jurisdiction. We have seen in some issues where, civil rights are violated, that we may see something of that nature. There was after the Trayvon Martin, the death of Trayvon Martin by George Zimmerman, it was argued that the federal government might try him under a civil rights violation, and arguing that the reason that he tried to stop the Trayvon Martin was because he was an African American, and solely on that sense was a violation of his civil rights. That was talked about, and that could have been done, but it was not pursued by the federal government. Mainly part of the Fifth Amendment is the exclusionary rule. It prohibits police or government actors from using illegally seized evidence. So say, my house, I have a grow in my house. So say I have a grow, I'm growing marijuana. And the police just, think they know I'm growing marijuana, but have no proof, and they just show up and raid my house, and they find that there's marijuana in my house. They have no other reason to know, but no other proof that led up to that, and they would not have been able to get a warrant. But they raid the house, and they get that, and that's what they do. And so, but they can't use the illegally seized evidence, so they wouldn't be able to use the marijuana against me. They just can't say, "Hey, we found this marijuana, and that's why he's guilty." Well, no, they would have had to have reason to raid my house, and they would have had to have gotten a warrant beforehand, or the warrant had to be in on its way for us to. In order for us to, already been gotten and approved by the judge and on its way in that regard. But no, if they just raided the house out of a whim, that's fruit of the poisonous tree. That's illegally seized evidence, can't be used in a trial, and that won't be used against me. No, I don't get my weed back. No, I don't get my apparatus to grow the weed back. But so it won't be used. Again, Ohio versus MAP extends the protection of the Fourth and Fifth Amendments to the states. So again, the Fourth and Fifth Amendments are protected on the federal and state level. The Sixth Amendment sets out the basic requirements for procedural due process for federal courts to follow in criminal trials. So we have speedy and public trial, impartial juries, trial in state where crime was committed, right of favorable witnesses, and right to counsel. These are all your procedural trial rights. These are rights that are afforded to you as a citizen if you are going through a trial. So again, Speedy and public trial, again, your trial is open to society. Impartial juries, again, juries of your peers who are going to make this decision, and they traditionally don't have they don't fall into that category of being biased in any way. And that's really hard to have, but you try to find the least biased people you can. Trials in state where the crime was committed. Right to favorable witnesses, again, bringing people on your behalf. And then again, the right to counsel. All of these are protections that you're given under the Sixth Amendment. One of the protections that's large under the Sixth Amendment is Gideon versus Wainwright, right to counsel. Lawyers are not luxuries, but are necessities. So Gideon was another individual that did not necessarily know what his rights were, and so Gideon's arrested. Doesn't know that he has the right to counsel, and so he's left to defend himself, and which is not a benefit to him. He doesn't know the legal system. As individuals, you want to pay and get an attorney, and a lot of us will take out loans for televisions and other things, but we won't take out a loan to pay your attorney. Pay your attorney, because usually you got to pay if you pay them. Pay for an attorney. I won't get on my soapbox about that. But again, pay for an attorney to protect your rights. They are the experts in these court procedures. You want to make sure that you get an attorney to protect what your rights are. And again, if you can't afford one will be afforded to you under the law through Gideon versus Wainwright. Having lawyers in a criminal trial is a necessity, not a luxury under the Sixth Amendment. Now, the Seventh Amendment is civil jury trials. Again, federally, that is a requirement. So if you have a federal issue and there's a civil matter that goes on, you're being sued on the federal level, you will be given a federal jury trial. However, on the state level, it's not a guarantee to the states. And so it is, unless you have it in the state constitution. Again, here you live where I live here in the state of Georgia, not in the Georgia Constitution. It's something that's given to you. And because it's not given to you, you have to pay for them. Now, you don't get to tell them that you paid for them, but they'll get to make the decision. You're going to have to pay the group of 12 hourly until your case is done, which can be expensive. That's why most people just let judges rule in someone's favor or not. So, the Eighth Amendment, excessive bails shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So there's two aspects here. Excessive bails shall not be required, nor excessive fines imposed. Again, that is not incorporated to the state. So a state can create depending on your state, if your state does not have this protection in the Constitution, you might have an excessive bail of millions of dollars or excessive fine that you have to pay if that's not incorporated into your state constitution as a protection. But no state can have any cruel and unusual punishment. So certain types of executions have been outlawed in certain states, and federally we've determined that there's no guillotines, there's vastly no firing squads unless you choose to do one. I think Utah still has the ability for the choice of a firing squad if you choose so, but again, there's no firing squads because usually those methods of death are deemed to be excessive. Many states don't have any electric chairs anymore because we've deemed those excessive again. Some states still do. Georgia, I can't remember if we do or not. But in many states, we don't have the electric chair anymore, again, due to the states usually have deemed those as not being appropriate. But again, the vast majority of people use lethal injection as their method of execution because it's deemed to be the least painful of the recourses that we have to this point. But some states have said that, death penalty is not allowable, and so they've been removed. Michigan, where I used to live, doesn't have the death penalty. And many other states across the United States do not, but certain states do. Georgia, which I live in, I was born in, has the death penalty. And so that's a recourse that they have. At one point, the death penalty was removed from Georgia because it wasn't being used correctly. It was arbitrary. We were kind of, the people who were doing wrong, people were having the same offenses and being charged and being convicted of the same crime, but depending on your racial background, certain people were being put to death more than others. We saw at one point in time, black people and other minorities were getting the death penalty more than white individuals who were doing the same crime. And so Georgia's ability to give the death penalty was removed by the Supreme Court and then later a statute was created, which created a kind of a standard about how you would be chosen for the death penalty, or how you would get the death penalty, and so that criteria was added back. So the right to privacy. The right to privacy, or the right to be left alone, is a judicially created right encompassing a variety of individual actions protected by the penumbras or the umbrella of certain amendments. The First, the Third, the Fourth, I would say the part of the Fifth, the Ninth, and the 14th all allude to a right to privacy. Again, nothing states that you have one, but it's a judicially created right where the courts say you do, and that's expanded to our understanding of the Constitution. And our right to privacy is born out of Griswold versus Connecticut. Griswold versus Connecticut is a case that challenged the 1879 Connecticut law that prohibited the giving out of information about contraception, condoms and other means of preventing pregnancy. Connecticut is a largely Catholic state, and because of that religious background, contraception is not allowable, and so the state passed a law saying contraception, the giving out of information about or the sale of contraception was not allowable. And so we get into the 1960s, and Griswold and her business partner are, selling people contraception and giving people information about contraception, and they're violated the law, and the Supreme Court rules that this is a violation of the right to privacy and the marital right to privacy at this point in time. So at first, they're going to give this right to privacy to married individuals, because there's certain things that happen in people's homes and people's bedrooms that are private. That's kind of the standard of how we understand this. And over time, we first gave it to married couples and mainly it's married couples of the same race. And then we gave it to, married couples of alternating races. And then we gave it to all couples. And then now we've expanded it to gay, lesbian, bisexual, and transgender couples. And so you've seen over time that this is expanded, because it didn't apply to everybody at first. It applied really to married couples of a particular background. And then we, certain laws and judicial decisions are created, and then it goes to all couples, and actually probably went to then interracial couples, and then couples of, same-sex origin. And so we see the expansion of that over time. Probably the biggest right to privacy case that exists is Roe versus Wade. It's argued about, and it's argued about even today. There's a huge argument about whether we'll see a Supreme Court case. I think actually there is a case that's going to the Supreme Court now that will kind of rehash some of what the foundations of Roe versus Wade are. Jane Roe, which is a pseudonym of a young lady who was pregnant, and she was in the state of Texas. And she was not allowed to gain an abortion or leave the state to do that medical procedure. Again, the medical procedure is left up to the states, whether they allow certain medical procedures. But the state of Texas said, hey, it's against the law for citizens of the state of Texas to have an abortion or leave the state to do an illegal act. Because a lot of laws don't allow you to leave a state to do an illegal act